Good evening and welcome to Primetime TV. My name is Paul Dollywell. ਮੇਰੇ ਵੱਲੋਂ ਕਮਿਊਨਿਟੀ ਨੂੰ ਪਿਆਰ ਭਰੀ ਸਤਿ ਸ੍ਰੀ ਅਕਾਲ। ਨਾਲ ਦੀ ਨਾਲ ਮੈਂ ਸਾਰੀ ਕਮਿਊਨਿਟੀ ਨੂੰ ਲੱਖ ਲੱਖ ਵਧਾਈ ਦੇਣੀ ਚਾਹੁੰਦਾ ਪਿੱਛੇ ਵਿਸਾਖੀ ਤੇ। ਜਿੱਦਾਂ ਅਸੀਂ ਦੱਸਿਆ ਸੀਗਾ ਅਸੀਂ ਪ੍ਰਾਉਸਟੈਸ਼ ਐਂਡ ਕਰਾਊਚ ਲਾਅ ਫਰਮ ਦੇ ਨਾਲ ਵੇਰੀਅਸ ਲਾਇਰਸ ਲੈ ਕੇ ਆਉਂਦੇ ਹੁੰਦੇ ਆ ਇਸ ਸ਼ੋ ਵੈਨਸਡੇਜ਼ 7:30 ਤੋਂ 8:30 ਤਾਂ ਅਸੀਂ ਵੇਰੀਅਸ ਏਰੀਆਜ਼ ਆਫ ਲਾਅ ਕਵਰ ਕਰਦੇ ਆ ਸੋ ਦੈਟ ਜਿਹੜੇ ਆਪਣੇ ਵਿਊਅਰਸ ਆ ਉਹ ਥੋੜੀ ਜਿਹੀ ਜ਼ਿਆਦਾ ਇਨਫੋਰਮੇਸ਼ਨ ਲੈ ਸਕਦੇ ਜਿਹੜੇ ਡੇ ਟੂ ਡੇ ਇਹਨਾਂ ਦੀ ਲੀਗਲ ਇਸ਼ੂਜ਼ ਹੁੰਦੇ ਆ। ਅੱਜ ਸਾਡੇ ਨਾਲ Dalkeith Palmer ਪ੍ਰਾਉਸਟੈਸ਼ ਐਂਡ ਕਰਾਊਚ ਵੱਲੋਂ ਆਇਆ। Dalkeith, welcome to Prime Time.
Oh, thank you, Paul.
Thank you for taking time out to be here.
I'm glad to be here, glad for the invitation and the opportunity to talk about law.
Why don't you tell us a little bit about yourself?
Well, I've been practicing law for about 20 years, and I've been with Proudstash and Crouch now for about 16 years. And my area of practice is commercial litigation, and under that umbrella, I practice shareholders dispute, debt collection, mortgage-related actions, construction lien work, and I also do employment law.
Okay. With respect to the various areas that you practice in, are you the only lawyer, or do you have a team of lawyers that work with you?
Well, PDC is all about teamwork, as you know. You've been at the firm for many years yourself. Yes. And we have 2 lawyers who do primarily employment law.
Okay.
But in terms of commercial litigation, we have about 4 lawyers who practice in that area.
No, it's great when you have a number of lawyers one can rely on based on their years of experience and knowledge.
Yeah, most definitely.
Excellent. You've indicated you cover a number of areas in commercial litigation. One of those areas is employment law.
Yes.
Why don't we talk a little bit about employment law and share with our viewers key points of employment law?
Certainly. For both employees and employers, employment law is like a minefield. And as I always say to clients, and by the way, I represent both employers and employees, and I try to let them know that it is always important to seek out an employment lawyer before you sign the contract, if you will, or you make any decisions, big decisions about employment law.
ਜਿੱਦਾਂ Dalkeith Palmer ਨੇ ਦੱਸਿਆ ਸੀਗਾ ਕਹਿੰਦਾ various areas of commercial litigation ਕਰਦੇ ਆ ਉਹਨਾਂ ਦੇ ਥੱਲੇ employment law ਵੀ ਆਉਂਦਾ ਤਾਂ ਬਹੁਤ ਕੀ important issue ਆਪਾਂ ਨੂੰ ਖਿਆਲ ਕਰਨਾ ਚਾਹੀਦਾ ਵਾ ਜਦੋਂ ਆਪਾਂ contract sign ਕਰਦੇ ਆ ਜਾਂ employer ਹੋਵੇ ਜਿਹੜਾ ਕਿਸੇ ਨੂੰ employ ਕਰਦਾ ਜਾਂ employee ਹੋਵੇ ਜਿਹੜਾ ਕਿਸੇ ਲਈ ਕੰਮ ਕਰ ਲਿਆ ਤੁਸੀਂ ਪਹਿਲਾਂ ਮੇਕ ਸ਼ੋਰ ਕਰੋ ਜਿਹੜਾ ਤੁਸੀਂ ਕੰਟਰੈਕਟ ਸਾਈਨ ਕਰਦੇ ਆ ਤੁਹਾਨੂੰ ਫੁੱਲੀ ਅੰਡਰਸਟੈਂਡ ਹੈਗੀ ਆ ਕਿਹੜੇ ਕਿਹੜੇ ਉਹ ਚ ਇਸ਼ੂਜ਼ ਆ ਤਾਂ ਕਿਹੜੇ ਕਿਹੜੇ basically related ideas ਹੈਗੇ ਆ ਜਿਹੜੇ ਤੁਹਾਨੂੰ ਮੇਕ ਸ਼ੋਰ ਕਰਨਾ ਪਊਗਾ ਤੁਸੀਂ ਉਸ ਏਰੀਆ ਚ knowledgeable ਹੈਗੇ ਆ as you've said you need to be well versed with respect to what's in an agreement before signing it.
Yeah, definitely. And I should point out that there are 2 pieces of legislation that govern employment relationships. And in Ontario, we have the Employment Standards Act.
Okay.
And we also have the Ontario Human Rights Code. With respect to the Employment Standards Act, that act basically sets out the minimum entitlement that an employee would be entitled to receive upon termination of the employment, for example. The Human Rights Code basically informs the employee of how the employee should be treated by the employer. For example, the employer cannot discriminate against the employee on certain recognized or acknowledged grounds that you find in the Ontario Human Rights Code.
So that's during the course of the employment?
During the course of the employment, and also before. Okay. Before the person is hired on, the employer, for example, cannot ask and should not be asking the employee or potential employee questions that could violate the code. So it's before the employment and during the employment.
ਜਿੱਦਾਂ ਆਪਣੇ ਡੌਕੀ ਉਹਨਾਂ ਨੇ ਦੱਸਿਆ ਸੀਗਾ ਕਹਿੰਦਾ ਬੇਸਿਕਲੀ ਜਿਹੜੇ ਰਿਲੇਸ਼ਨਸ਼ਿਪ ਹੈਗਾ EMPLOYER ਤੇ EMPLOYEE ਦੇ ਨਾਲ ਆ ਦੋ ਲੈਜਿਸਲੇਸ਼ਨਾਂ ਜਿਹੜੇ ਗਵਰਨ ਕਰਦੇ ਇੱਕ ਤਾਂ ਹੈਗਾ EMPLOYMENT STANDARDS ਐਕਟ ਇੱਕ ਹਿਊਮਨ ਰਾਈਟਸ ਜਿਹੜਾ ਐਕਟ ਹੈਗਾ ਤਾਂ ਨਾਲ ਦੀ ਨਾਲ ਆਪਾਂ ਨੂੰ ਇਹ ਖਿਆਲ ਕਰਨਾ ਚਾਹੀਦਾ ਵਾ ਜਿਹੜਾ EMPLOYEE ਆ ਸਰਟਨ ਕੁਐਸਚਨਸ ਜਿਹੜੇ EMPLOYERS ਆ ਉਹ ਤੁਹਾਨੂੰ ਪੁੱਛ ਨਹੀਂ ਸਕਦੇ ਤਾਂ ਹੁਣ ਆਪਾਂ ਡੌਕੀ ਦੇ ਨਾਲ ਇਹ ਕੁਐਸਚਨਸ ਪੁੱਛਾਂਗੇ ਕਿਹੜੇ ਕੁਐਸਚਨਸ ਇਨਅਪਰੋਪਰੀਏਟ ਆ ਤੇ ਕਿਹੜੇ ਕੁਐਸਚਨਸ ਜਿਹੜੇ EMPLOYEES ਆ ਜਿਹੜੇ ਉਹਨਾਂ ਨੂੰ ਨਹੀਂ ਆਨਸਰ ਕਰਨ ਦੀ ਲੋੜ So, Delki, for example, as you said, before employment.
Yes.
What type of questions are not to be asked by an employer?
For example, an employer shouldn't be asking an employee about their religion, about their creed. Shouldn't be asking the employee or potential employee about his family status. Should be asking the employee about their sexual orientation, for example.
Okay.
Those questions are forbidden according to the code.
ਜਿੱਦਾਂ ਡੌਕੀ ਨੇ ਦੱਸਿਆ ਵਾ ਜੇ ਤੁਸੀਂ EMPLOYEE ਆ ਤਾਂ ਤੁਸੀਂ ਇੰਟਰਵਿਊ ਵਾਸਤੇ ਜਾਂਦੇ ਆ ਤੁਹਾਨੂੰ ਇਹ ਪਤਾ ਹੋਣਾ ਚਾਹੀਦਾ ਜਿਹੜਾ ਤੁਹਾਡਾ EMPLOYER ਆ ਜਾਂ ਪ੍ਰੋਸਪੈਕਟਿਵ EMPLOYER ਆ ਉਹ ਸਰਟਨ ਕੁਐਸਚਨਸ ਤੁਹਾਨੂੰ ਪੁੱਛ ਨਹੀਂ ਸਕਦਾ ਉਹ ਤੁਹਾਨੂੰ ਇਹ ਨਹੀਂ ਪੁੱਛਦਾ ਤੁਹਾਡਾ ਰਿਲੀਜਨ ਕੀ ਆ ਤੁਹਾਡੀ ਫੈਮਿਲੀ ਸਟੇਟਸ ਕੀ ਆ ਜੇ ਤੁਸੀਂ ਡਿਵੋਰਸਡ ਆ ਜਾਂ ਤੁਸੀਂ ਮੈਰਿਡ ਆ ਜਾਂ ਤੁਸੀਂ ਸਿੰਗਲ ਆ ਨਾਲ ਹੀ ਨਾਲ ਉਹ ਤੁਹਾਡੇ ਬੇਸਿਕਲੀ ਸੈਕਸ਼ੂਅਲ ਓਰੀਐਂਟੇਸ਼ਨ ਬਾਰੇ ਵੀ ਪੁੱਛ ਨਹੀਂ ਸਕਦੇ what happens if a employer does engage in asking questions along those lines?
Well, the reason why an employee would ask certain questions that would violate the code would be to, in my mind, discriminate against that potential employee.
Right.
So if at the end of the day that employee does not or did not get the job, then it's reasonable for that employee to assume that he or she did not get the job because the employer knew, for example, that he was gay or she was gay. And if the employee feels that the employer discriminated on one of those bases,
grounds,
yes, then the employee can actually bring a complaint with the Ontario Human Rights Commission against that employer.
Okay, let's take a case scenario.
Yes.
An individual applies for a job. It's advertised in a local paper or on the internet on one of the job sites, and their qualifications seem adequate, and they're called in for an interview. They're asked one of these questions that you indicated are improper for an employer to ask of a potential employee. At some point, the employee is advised that we found someone else. At that point, can you assist that potential employee?
Well, I think I could, because if the employee or potential employee, the client, my client,
yes,
that would be in this case, satisfied all of the criteria, all of the requirements, and was ignored or not hired on for the job. And if, for example, this person was a visible minority, or this person during the course of the interview was asked about their sexual orientation and gave an answer, it could be assumed that the person did not get the job because of the answer given to the employer, or because of the person's race. So in that case, I would say to the employee that there may be a case here for on the basis of discrimination by that employer or that potential employer.
ਜਿੱਦਾਂ ਮਿਸਟਰ ਪਾਮਰ ਨੇ ਦੱਸਿਆ ਵਾ ਜੇ ਤੁਸੀਂ ਫੀਲ ਕਰਦੇ ਆ ਜਿਹੜੇ ਸਰਟਨ enumerated provisions ਆ ਹਿਊਮਨ ਰਾਈਟਸ ਕਮਿਸ਼ਨ ਜੇ ਤੁਸੀਂ ਉਹਨਾਂ ਦੇ ਉੱਤੇ ਡਿਸਕ੍ਰਿਮੀਨੇਟਡ ਹੋਏ ਆ ਤੁਸੀਂ ਡੈਫੀਨਿਟਲੀ ਲੀਗਲ ਐਡਵਾਈਸ ਲੈ ਸਕਦੇ ਆ Delki, as you said, based on a number of factors that have been enumerated in the code, sex, race, religion, if someone decides to hire somebody because they're either a male or a female, and or because of their language skills, and it's a bona fide requirement of the job. For example, you're working in a certain type of restaurant, and you must have those language skills. Would that be justified?
Well, exceptions, if you will, or there are scenarios or cases where one could technically discriminate if the job or part of the job requirement touches upon one of those enumerated grounds. For example, if someone is going to hire a truck driver, normally, if someone applies for a job, then the employer shouldn't be asking the potential employee about a driver's license. But if the person is applying for a truck driving job, then it's reasonable to ask the person whether or not the person can drive or whether or not the person has a license. So it depends. If the question that is asked is significant to the job that is being applied for, then I think in that case, the employer in this case, would be able to get away with asking questions that ordinarily or normally would be a breach of the code.
Let's take an example. For example, we have a restaurant. It's a restaurant that typically caters to a certain group of individuals, or they have clientele that usually come in and let's say order in Punjabi. Would that restaurant owner, the employer, be entitled to say that we want to hire somebody that has Punjabi as a language skill?
I don't think that would be a breach of the code to set out specifically that one of the requirements or a primary requirement of the job is the ability to speak in Punjabi. Given that the clientele of that restaurant owner would be primarily or mostly people from that community.
Right.
So in that case, I think it would be fine for the ad, if you will, to indicate that the successful applicant would have to have the ability to speak Punjabi.
ਜਿੱਦਾਂ ਡਾਕੀਸ ਨੇ ਦੱਸਿਆ ਵਾ ਆਪਣੇ ਐਕਸੈਪਸ਼ਨਸ ਹਰੇਕ ਕਾਨੂੰਨ ਦੇ ਨਾਲ ਹੁੰਦੇ ਆ ਯੂਜੂਅਲੀ ਡਿਸਕ੍ਰਿਮੀਨੇਸ਼ਨ ਤਾਂ ਹੋ ਨਹੀਂ ਸਕਦੀ ਬਟ ਕਦੀ ਕਦੀ ਬੋਨਾਫਾਈਡ ਰਿਕੁਆਇਰਮੈਂਟਸ ਹੁੰਦੇ ਆ ਫॉर ਐਗਜ਼ਾਮਪਲ ਲੈਂਗੁਏਜ ਰਿਕੁਆਇਰਮੈਂਟ ਰਾਈਟਸ ਔਰ ਲੈਂਗੁਏਜ ਰਿਕੁਆਇਰਮੈਂਟ ਪ੍ਰੋਫੀਸ਼ੀਐਂਸੀ ਹੁੰਦੀ ਆ ਫॉर ਐਗਜ਼ਾਮਪਲ ਬਿਕਾਜ਼ ਤੁਸੀਂ ਉਸ ਮਾਰਕੀਟ ਨੂੰ ਕੇਟਰ ਕਰਨਾ ਬਟ ਉਹ ਜਿੱਦਾਂ ਡਾਕੀਸ ਨੇ ਦੱਸਿਆ ਉਹ ਇੰਡੀਵਿਜੂਅਲ ਕੇਸ ਬਾਈ ਕੇਸ ਸਿਨੈਰੀਓ ਹੁੰਦਾ ਵਾ let's just hold on a sec before we move forward. We've got a call. Let's just take this call.
Certainly.
Good evening, primetime.
PTN24.
Record your message at...
Good evening, primetime. I think we've lost
that caller.
That caller. Yeah. So I understand that there are certain requirements that may be in place with respect to that. Let's talk a little bit about the type of notice an employer would have to give an employee with respect to termination.
Okay. Well, again, like everything in law, it depends. And if someone worked, for example, at a company for a year, and the employer decides to terminate that employee, then that employer would have to give the employee notice or pay that person in lieu of notice, which in this case would be a week's notice. The Employment Standards Act provides for, and it increases as the more years the person works at the company. There's a maximum notice, however, which is 8 weeks. So
okay.
if you work, say 8 years or more, the maximum or the notice that you should receive, according to the Act, would be 8 weeks.
So it's 1 week per year. Under the Act?
Under the Act, it would be up to, if you work 8 years or more, you're maxed out at 8 weeks. If you work, for example, 5 years, it would be 5 weeks notice or 5 weeks pay in lieu of notice. But we have to keep in mind that we're only talking about the act itself, okay? Because apart from the statutory scheme or the act, there's also the common law that comes into play in determining how much notice an employee is entitled to. But if we stick with the act for a moment, and let's use an example. This person works at a company for, say, 5 years,
Yeah.
and the company is a large company. There are two components to the act. One is the notice component, and one is the severance component.
Yeah.
And if the person worked at the company for 5 years and is terminated without cause, then that person is more than likely entitled to the 5 weeks notice or 5 weeks pay in lieu of the notice, in addition to the severance, which would be a week for each year that that person worked at the company. So the minimum under the act then would be a total of 10 weeks in that scenario.
Let's just hold on again. We've got a caller again. Let's see if we get better luck this time.
Okay.
Good evening. Prime time.
PTN24.
Record your message at the
We're having some technical difficulties with the phone right now. Okay, so in addition to the weeks of notice or notice in lieu of, what about the benefits?
Well, the benefits are typically benefits arising from the particular contract as between the employee and the employer at that time. And the Act itself provides for, allows for certain things, like the employee can get time off for sickness, the employee gets vacation time, and so on. So if you want to characterize those as benefits, yes, then those are available as per the Act. But the other benefits, such as health benefits, benefits that may have to do with your dental, for example, car allowance, and so on, those are usually benefits that arise out of the specific employment contract.
Could those be extended beyond the notice period? For example, an individual is relying on certain medications, and the employer offers medication as part of a benefits package. In addition to the notice period and the severance, would they still be eligible for the benefits arising out of the benefits that are offered?
Well, when I act for employee clients, I tend to push the employer to pay for additional benefits or benefits post termination. And the reason for that is, if at the end of the day I determine that my client is entitled to, say, 10 months of notice, and that would include the statutory notice and the common law notice, which I didn't really talk about. But if at the end of the day I determine that my client is entitled to, say, 10 months notice and he's terminated, then my request to the employer would be that the benefits should follow through the notice period.
Okay.
So after the client term is terminated, for 10 months, the client would be entitled to get those benefits, whatever benefits the client used to get under the employment contract.
During that time period.
Yes.
We're going to try again one more time. Hopefully we're successful with
Okay.
this call. Good evening. I think we're having a lot of technical difficulties this evening. All right. Now, if an employee is working for a employer and the employer feels the employee isn't up to the task or they're not working at the required level they ought to be, can you assist an employer with respect to putting together some type of package before that employer meets with an employee?
Certainly, and one thing to keep in mind is that an employer has the right to terminate an employee generally
Okay.
any time without cause, or it can be the employer may have just cause to terminate the employee. But if the employer decides or feels that the employee is not pulling his weight and the employer wants to terminate that employee, then yes, that employer can go ahead and terminate that employee, providing that the employer gives adequate notice or pay that employee in lieu of notice.
So, and that's notice that we talked about under the Employment Standards
Under
Act
the
and the common law.
Under the Employment Standards Act and also common law, yes, definitely. I'm sorry.
Are all employees treated equally in the sense that, for example, if somebody's a general laborer or if somebody's a senior level executive with maybe 35 years of experience?
Well, and that's where the common law comes in, because the common law looks at various factors in determining how much notice the employee should get. So someone who, say, is the VP of sales in a company versus someone who is the common laborer, for example, the court may look at those two individuals differently, citing the person who's the VP of sales as
Right.
perhaps more important to the organization and therefore more deserving of notice.
ਜਿੱਦਾਂ ਡਾਕੀਸ ਨੇ ਦੱਸਿਆ ਵਾ ਹਰੇਕ EMPLOYEE ਦੀ ਸਿਚੁਏਸ਼ਨ ਸੇਮ ਨਹੀਂ ਹੁੰਦੀ ਤੁਹਾਨੂੰ ਲੀਗਲ ਐਡਵਾਈਸ ਲੈਣੀ ਚਾਹੀਦੀ ਹੈ ਡਿਪੈਂਡਿੰਗ ਔਨ ਤੁਹਾਡੀ ਕੀ ਆਕੂਪੇਸ਼ਨ ਆ ਤਾਂ ਤੁਸੀਂ ਕਿੰਨਾ ਚਿਰ ਕਿਸੇ ਕੰਪਨੀ ਨਾਲ ਲੱਗੇ ਰਹੇ ਆ ਫੋਰ ਐਗਜ਼ਾਮਪਲ ਜੇ ਤੁਸੀਂ ਜਨਰਲ ਲੇਬਰ ਆ ਜਾਂ ਤੁਸੀਂ ਵਾਈਸ ਪ੍ਰੈਜ਼ੀਡੈਂਟ ਆ ਕਿਸੇ ਕੰਪਨੀ ਨਾਲ ਉਹ ਡਿਪੈਂਡ ਕਰਦਾ ਕੀ ਤੁਹਾਡੀ ਸਿਚੁਏਸ਼ਨ ਆ ਤਾਂ ਕੀ ਤੁਹਾਡੀ ਐਬਿਲਿਟੀ ਆ ਗਾਂ ਵੀ ਕੰਮ ਲੱਭਣ ਨੂੰ is there also some issues with respect to how employable that person could be in the future?
Oh yeah, definitely, and that is where age comes in, and age is a factor that the court will look at. Mm-hmm. And the thinking is that the older the person or the older the employee, the more difficult that person is going to have in finding a new job. So in that case, that person or that older person would get more notice, more common law notice, if you will. The other factor too is the economy, because if the economy is not going well, then that will affect the person's ability to find new jobs. So that's another factor that a court will look at in determining.
Case scenario. We have an individual that is terminated. Does that individual who is terminated have an obligation to go out and try and find employment, or can they sit at home for a number of months until they find the job that they want?
And that's a good question, because part of employment law, a huge part of employment law, has to do with mitigation. And
what does mitigation mean?
Well,
let's break down that.
Yes. Well, mitigation is, and you described it beautifully when you said that someone's sitting at home and not doing anything and perhaps just waiting for the ideal job to come along. But mitigation really is one having the responsibility to go out and find a replacement job, if you will, and not just sit home, watch TV, and do nothing. So, and mitigation is a factor that comes into play many times. And right now I have cases that mitigation in all of the, most of the cases that I have come into play and are playing and is playing a significant role in determining how much notice or how much money my client is going to end up getting at the end of the day.
Okay, so with respect to mitigation, generally speaking, an individual that is terminated has an obligation to lessen their loss.
Yes.
As we could say, layman's terms. So they should try and take what employment is available in a relevant field?
Yeah, you try to find a job that is very close to the one that you lost.
Okay.
Okay. So in my experience, if someone was an engineer at a company,
Yeah.
I wouldn't expect that person to go and get a job at McDonald's.
Right.
Even though the lawyer on the other side would want to argue that, well, they had an opportunity to go to McDonald's and work, and they didn't mitigate their losses. But I think the court looks at the type of job that the employer or the employee, the terminated employee, would be able to get at the end of the day.
ਜਿੱਦਾਂ ਆਪਣੇ ਡੈਓਕੀਸ ਨੇ ਦੱਸਿਆ ਫੋਰ ਐਗਜ਼ਾਮਪਲ ਜੇ ਤੁਸੀਂ EMPLOYEE ਆ ਤਾਂ ਤੁਸੀਂ ਟਰਮੀਨੇਟਡ ਆ ਆਬਵੀਅਸਲੀ ਲੀਗਲ ਐਡਵਾਈਸ ਲੈਣੀ ਚਾਹੁੰਦੇ ਆ ਤੁਹਾਨੂੰ ਲੈਣੀ ਚਾਹੀਦੀ ਆ ਬਟ ਨਾਲ ਨਾਲ ਇਹ ਵੀ ਖਿਆਲ ਕਰਨਾ ਚਾਹੀਦਾ ਵਾ ਤੁਸੀਂ ਬੇਸਿਕਲੀ ਘਰੇ ਨਹੀਂ ਬਹਿ ਸਕਦੇ ਤੁਸੀਂ ਇਹ ਨਹੀਂ ਕਹਿ ਸਕਦੇ ਫੋਰ ਐਗਜ਼ਾਮਪਲ ਸਾਡੀ ਪਹਿਲਾਂ ਇਹ ਜੌਬ ਸੀਗੀ ਤਾਂ ਸਾਡੀ 80,000 ਜਾਂ 90,000 ਜਾਂ $1,00,000 ਤਨਖਾਹ ਸੀਗੀ ਤਾਂ ਅਸੀਂ ਕੰਮ ਨਹੀਂ ਕਰਨਾ ਜਿਹੜੇ ਕੋਰਟਸ ਆ ਉਹਨਾਂ ਨੇ ਦੇਖਣਾ ਵਾ ਤੁਸੀਂ ਕੀ ਅਟੈਂਪਟਸ ਕਰਦੇ ਆ ਜੌਬ ਲੱਭਣ ਨੂੰ ਤੇ ਨਾਲ ਦੀ ਨਾਲ ਤੁਸੀਂ ਕੀ ਅਟੈਂਪਟਸ ਕਰਦੇ ਆ ਆਪਣੀ ਬੇਸਿਕਲੀ ਜਿਹੜੇ ਡੈਮੇਜਸ ਉਹ ਮਿਟੀਗੇਟ ਕਰਨ ਨੂੰ ਉਹਦਾ ਮਤਲਬ ਰਿਡਿਊਸ ਕਰਨ ਨੂੰ ਤੁਸੀਂ ਬੇਸਿਕਲੀ ਇਹ ਨਹੀਂਗਾ 6 ਮਹੀਨੇ ਜਮ੍ਹਾਂ ਕੰਮ ਨਾ ਕਰੋ ਬਟ ਜਿੱਦਾਂ ਡੈਓਕੀਸ ਨੇ ਦੱਸਿਆ ਵਾ ਜੇ ਤੁਸੀਂ ਐਗਜ਼ੈਕਟਿਵ ਆ ਤਾਂ ਤੁਸੀਂ ਉਸ ਫੀਲਡ 'ਚ ਜੌਬ ਲੱਭ ਸਕਦੇ ਆ ਇਟਸ ਗੁੱਡ ਬਟ ਕੋਈ ਐਕਸਪੈਕਟੇਸ਼ਨ ਇਹ ਨਹੀਂਗਾ ਜਿੱਦਾਂ ਇਹਨਾਂ ਨੇ ਦੱਸਿਆ ਇਹਨਾਂ ਦੀ ਐਕਸਪੀਰੀਅੰਸ ਦੇ ਵਿੱਚ ਤੁਸੀਂ ਜਾ ਕੇ ਫੋਰ ਐਗਜ਼ਾਮਪਲ ਜਨਰਲ ਲੇਬਰ ਜੌਬ ਕਰੋ Dalkeith, we're talking about a lot of important things in relation to employment law. Is there certain information you could share with the viewers with respect to when you think an employee should come and see an employment lawyer? What I basically mean is, let's just say the employee is not terminated, but they feel that the employer is doing certain things or they're acting in certain ways towards them that they feel that they really can't continue with their job.
And before I speak to that issue specifically, what I would say to all employees or potential employees is if you're going to be signing a contract, before you sign that contract, you should get legal advice. And the reason why I say that is I see so many contracts where if the employee had just taken 2 hours or an hour and have someone look over the contract, they would have saved themselves a lot of trouble.
Can an employee ask the employer gives them a contract signed, can they say to them, you know what, I'd like 2 days or 48 hours to review this and then get back to you?
Certainly. And I think it's also in the employer's best interest to have that done because at the end of the day, the employer can say that, well, you had an opportunity, employee, to go out and get legal advice with respect to the contract. But
ਜਿੱਦਾਂ ਆਪਣੇ ਡੈਓਕੀਸ ਨੇ ਦੱਸਿਆ ਵਾ ਜੇ ਤੁਸੀਂ EMPLOYEE ਆ ਤਾਂ ਤੁਹਾਡਾ employer ਤੁਹਾਨੂੰ contract ਦਿੰਦਾ it's very important ਬਹੁਤ ਖਿਆਲ ਕਰੋ ਪਲੀਜ਼ ਕੋਈ contract sign ਕਰਨ ਤੋਂ ਪਹਿਲਾਂ ਤੁਸੀਂ legal advice ਲਓ ਜੇ ਤੁਸੀਂ ਫੀਲ ਕਰਦੇ ਹੋ ਤੁਸੀਂ legal advice ਨਹੀਂ ਲੈਣੀ at least ਉਹ ਜਿਹੜਾ document ਆ ਘਰੇ ਲੈ ਕੇ ਆਓ review properly ਕਰੋ don't feel rushed ਤਾਂ ਫਿਰ ਜਦੋਂ ਤੁਸੀਂ absolutely sure ਉਸ ਜਿਹੜਾ contract ਆ ਉਹਨਾਂ ਦੇ ਕੀ contents ਆ ਫਿਰ ਤੁਸੀਂ sign ਕਰਿਓ with respect to the question that I posed.
Yes.
If an employee feels that we're not being treated fairly and the climate at work is such that the employer is making it very difficult for us. You know, things were a lot different, but for some reason the employer doesn't want to terminate them, but you know, they make them do jobs that they weren't routinely doing, or the attitude at the office is a lot colder. Can an employee seek assistance from an employment lawyer at that stage, or is that too early?
no, if the employment or the nature of the employment is changed fundamentally, then the employee may have a ground or basis to basically challenge what the employer is doing. So, for example, if the employer contracted to get $200,000 a year,
Right.
or $100,000 a year, and 6 months into the employment, the employer says, "Sorry, Paul, I've got to reduce your salary by $50,000."
Okay.
Without any justification. That could be seen as a fundamental change to the employment contract, which could lead to a constructive dismissal. the employee in that case would have a case, in my view, for a constructive dismissal or wrongful dismissal as against the employer because of a change in a fundamental term of the employment contract.
Constructive dismissal, wrongful termination. I think we could go on for hours on that. We could probably do shows on that. But I can't believe we're almost coming to the conclusion of the show today.
Really?
Yes, time just flies.
Time flies.
I want to thank you very much for taking time out of your schedule to be here. You're sharing knowledge of employment law. Obviously, it's just general knowledge. Can you please share your contact information and your office hours with our viewers and let them know how they can best reach you?
Oh, certainly. As I said before, I work at Proust & Crouch. It's one of the largest firms in Brampton, and we're actually downtown Brampton. My number is 905-451-6610. That's the general reception line, or you may call me directly at 905-866-5180. Again, it's Proust & Crouch, and I'd be happy to help you with your employment law matters or any other commercial related issue that you may have.
Okay, thank you so much.
Thank you, Paul.
Thank you ਆਪਣੇ viewers ਨੂੰ again ਜਿਹੜਾ ਤੁਸੀਂ ਟਾਈਮ ਕੱਢ ਕੇ ਸਾਡਾ ਸ਼ੋ again view ਕੀਤਾ ਜਿੱਦਾਂ ਅਸੀਂ ਦੱਸਿਆ ਵਾ ਅਸੀਂ centrally located downtown Brampton, highway 10 and Queen major intersection, actually Queen and George Street, conveniently located. ਸਾਡੇ office hours ਹੈਗੇ ਆ basically 8 to 5:30 ਤਾਂ ਨਾਲ ਅਸੀਂ evening and weekend appointments ਵੀ ਦਿੰਦੇ ਆ ਤਾਂ ਸਾਡਾ phone number ਹੈਗਾ 905-451-6610. Thank you very much.